The Secure America Act, what you must know now. The Secure America Act is here, and it's already rewriting the rules of U.S. immigration in ways few expected. Signed earlier this year and fully activated in August 2025, this law is not about border walls or public headlines. It's about a deep, integrated enforcement system that quietly links immigration files with multiple federal databases. Why even longtime green card holders, people who thought their status was safe, are now facing sudden denials, unexpected background checks, and rules that leave no room for mistakes. A digital enforcement network. Unlike past policies that relied heavily on officer discretion, the Secure America Act centralizes decision-making and automates risk detection. From August 1st, USCIS began mandatory biometric collection for nearly all applications. Fingerprints, facial scans, and digital identity checks are now routine. What makes this unprecedented is the real-time data sharing between USCIS, the IRS, the Department of Labor, the DMV, and Social Security. If there's a mismatch, say your tax address doesn't match your immigration form, or your reported income differs between filings, your case can be flagged instantly. Many applicants don't even realize small inconsistencies exist until their application is delayed, audited, or denied. Green card renewals are no longer routine. Renewing a green card, once a relatively straightforward process, now triggers a full background and financial review. Officers can pull decades of records, immigration history, employment data, even sealed or dismissed legal cases. Under H.R. 1, every renewal is treated like a brand new application. That means you're not only proving your eligibility again, but also that your past record contains nothing questionable. This change has caught many long-term residents by surprise. People who have lived and worked in the U.S. for decades are now facing requests for evidence or, worse, referral to enforcement agencies without prior warning. Public charge rules, stricter than ever. The law revives and strengthens the public charge rule from 2020. Even short-term use of benefits like Medicaid, food stamps, or housing aid can now weigh against you. Officers aren't just looking at your current situation, they are reviewing years of financial history. Sponsors, too, are under new pressure. Affidavit of support filings, Form I-864, must be airtight, backed by 3 years of tax returns, job verification letters, and consistent bank statements. Any gaps or vague explanations are now more likely to lead to denials. Fee waivers nearly eliminated. Another change hitting applicants hard is the near elimination of fee waivers. Unless your income falls well below the federal poverty line, your waiver request will almost certainly be rejected. And there's no second chance. If your waiver fails, your entire application can be returned without review. This applies across categories, from DACA renewals to citizenship filings. August 21st, the second wave. The law's second enforcement phase begins August 21st with identity cross-checks against DMV records and expanded green card rescreenings. This phase will also fully enforce the tightened public charge standards. Every applicant will be treated like a first-timer, regardless of how long they've been in the U.S. For those with pending applications, this means your case could suddenly face a deeper review mid-process. Who benefits and who's at risk? While the law creates significant hurdles, it can also speed up cases for applicants with clean, consistent records. Automation means that if your file matches across all systems, tax returns, addresses, employment, you could see faster approvals. Those most at risk include applicants with sealed or dismissed charges, past benefit use, under-the-table work history, or tax filing gaps. Even small mismatches between IRS data and USCIS forms can now trigger red flags. Preparing for the new standard. To survive this stricter system, applicants should assemble a comprehensive file before submitting anything. This includes valid passport and copies of all prior immigration documents, 3 years of complete tax returns and W-2 or 1099 forms, employment verification letters and recent pay stubs, proof of continuous residence, police clearance or FBI background check if there is any legal history. These steps aren't just best practices, they're your defense against automatic denials in an enforcement-first environment. The biggest unseen shift is psychological. Immigration law has quietly moved from being primarily about eligibility to being about audit risk. Officers are now trained to look for mismatches before they look for merits. This means the most dangerous thing an applicant can do isn't having a complex history, but underestimating how that history appears across interconnected databases. Even well-meaning applicants who think they're safe can be caught off guard if they haven't reviewed their own records as critically as the government will. Final thoughts. The Secure America Act is a reset button for U.S. immigration, creating a high surveillance, zero margin for error environment. Whether you're renewing a green card, applying for naturalization, or sponsoring a family member, the key to success is preparation and consistency. In this new system, strong records mean speed, but inconsistencies, no matter how small, mean trouble. This is not a time for guesswork. If you're unsure, consult an immigration attorney who understands both the legal and data-driven sides of the process. Stay informed, stay prepared, and protect your future. Because once your case is flagged, reversing that decision may be harder than winning the case in the first place. Please don't forget to like, subscribe, and share. Thank you for watching.